In the early 1880s, as the peace policy as conceptualized by the Grant administration in the late 1860s, early 1870s came to an end, a new form of thought, a new way of dealing with the tribes, a new sensibility about federal Indian policy began to emerge. And it came from the private sector in large part, in a sense from Protestant religious individuals, less than organizations, but from new associations that were starting to form across a variety of issues, lines in the United States at that time. And some of these new associations decided to dedicate themselves to what they perceived to be the welfare of American Indians. Some of these groups were directly inspired in their establishment by the plight of Chief Standing Bear of the Poncas and others. At the time, these were emotionally compelling cases that invited the participation of people out to organize to do good. And this is a great era of private association, a great era in which people are sort of acclimated to and comfortable with the idea of forming private civic organizations to supplement things that the government's doing. And in this instance, these groups became very powerful, but again, outside the government, which makes this era different from the era of the Grant administration's peace policy, the administration in that period incorporating religious organizations in the implementation of federal Indian policy. Some of these groups, which started organizing in the late 1870s, early 1880s, included, and I'll just name a couple of the more important of these groups, the Women's National Indian Association, which included a number of Baptist members, which organized under that name in Philadelphia in 1883. And the most important of them, the Indian Rights Association, which organized in Philadelphia in 1882. But there were others, and collectively these groups saw themselves as the Friends of the Indian, and that's sort of the collective capital F, capital I, under which historians know them and think about them and write about them today. And as you'll see, there's a certain irony to that nomenclature as well. The goal of the Friends of the Indian, of these various associations, eventually came to be Americanization of individual tribal members, full-blown assimilation, letting the benefits of civilization flood into Indian country was something they saw as desirable. Civilization included ownership of private property, respect for law, and the way it was phrased, for the protection and punishment of law, and practical education, which turned out to mean technical or manual skills education. And we'll see how that plays out in the projects of the Friends of the Indian in a little bit. Reservations, which these organizations initially saw as an important part of the process, as we'd seen in the peace policy era, confining tribal members to particular patches of ground and making those areas protected areas from bad influences by non-Indians, that the Friends of the Indian began to see as a negative. And so it's in this group that we start seeing an enthusiastic advocacy for abolishing reservations, for carving them up, selling off surplus lands, and dividing the reservations up into individual farms. This eventually will culminate in the General Allotment Act of 1887, which we'll turn to in a few minutes. The Friends started meeting annually in 1883. These various associations convened at Lake Mohonk in New York. The Lake Mohonk Conference became the largest assembly of private sector advocates of assimilation in the United States, and the conferences continued through the 1880s and 1890s, and a lot of lobbying decisions were made there, which were then acted upon in Washington as these various associations sent representatives to the nation's capital to attempt to persuade the President and members of Congress of the wisdom of the positions that they were advocating concerning the best method for rapidly Americanizing or assimilating individual tribal members, of course as was perceived to be in their best interest. There were opponents of this policy, opponents of the Friends, advocates of tribes who were actually advocates of tribes and of the preservation of traditional Indian ways. The most important of these organizations was the National Indian Defense Association, which was organized in 1885 by a man named Thomas Bland, but they were in the minority, the pro-tribal, pro-traditional groups during this period, and the Friends of the Indian, especially the Indian Rights Association, eventually came to set the federal Indian policy agenda for most of the 1880s, and in a certain sense beyond. Their lobbying resulted in the breakup of the Great Sioux Reservation. This is the conflict over the acquisition of the Black Hills, where gold was found, etc. They were influential, I believe, in persuading the Interior Department to establish a new judicial system in Indian country. This is the bringing of the protection and punishment of law to Indian country. This judicial system called the Courts of Indian Offenses, which were established by Interior Department regulation in the administration of Secretary of the Interior Henry Teller in 1883 with no statutory authorization. The Interior Department just decided at each of these agencies, we're going to set up a court. We're going to call it the Court of Indian Offenses, which gives you a clue as to what it was intended to do. And that's to get Indians to behave properly. So the initial jurisdiction grant included misdemeanors, so they were a criminal law enforcement court and staffed by primarily, if not exclusively, by tribal member judges under the direction and regulation of the Interior Department, to be sure. But the court was given initially jurisdiction to stop dances like the traditional sun dance, which a number of the Northern Plains tribes had done and now do again. It's a ceremonial dance and other dances that had religious connections, many of them. The Courts of Indian Offenses were given jurisdiction to stop polygamy. Polygamous marriages were illegal, and if you discovered one, the Indian agent could bring charges against the parties in the Courts of Indian Offenses, or the appropriate Court of Indian Offenses, and they could break it up and punish people, usually by fines. Medicine men, perennial bane. If medicine men were caught to be interfering with the process of civilization, these are traditional healers and spiritual leaders, then they could be called before the Court of Indian Offenses and fined for interfering with the process of civilization, theft and destruction of property as well, intoxication, introduction of alcohol, all punishable in the Courts of Indian Offenses with actions initiated by the Indian agent. So these really are policing agencies created by and administered by the Department of the Interior in order to police the civilizing process. In a sense, they're playing the role vis-a-vis individual Indians that the military did vis-a-vis tribes back during the peace policy era, administering with severity the various prescriptions of the law anytime there's perceived to be a straying away from the path of civilization. I might note that these courts still exist, these Courts of Indian Offenses, with their regulations set forth. Now their jurisdiction is much more expansive, and this old anti-cultural jurisdiction has been abolished. But because their rules of procedure are found in the Code of Federal Regulations, because they were created by regulation by the Interior Department back in 1883, we more commonly call them CFR courts. And there's one at Anadarko, and there's CFR courts all over the United States. In recent years, the last 20 or 30 years, they've been largely replaced by tribal courts that are created and operated by individual tribes. That's something we'll talk about in the final lecture in this course. But for a long time, these CFR courts, or Courts of Indian Offenses, were the principal courts for the resolution of dispute in Indian country, and they had their birth in this era of sort of association-driven reform of federal Indian policy. Boarding schools were also created during this period all over the United States. We had talked during the peace policy lecture about the government creating creating schools in Indian country, staffed by teachers that were usually drawn from various religious bodies, in order to bring civilization and language instruction, this sort of thing. This new group, the Friends of the Indian, decided that that wasn't radical enough, that if we were going to sort of flood the tribes with the benefits of civilization, then we had to get them away from their families, these children. We had to get them out of the potential bad influence of the tribal communities in which they were living and going to school, and send them to some place like, this is the most famous of these, Carlisle, Pennsylvania, where a man named Richard Henry Pratt, a former Army officer, had established something in 1879 called the Carlisle Indian Industrial School. Carlisle, Pennsylvania, not commonly thought of as Indian country, but fairly far away from Indian country. The school lasted for a long time. Pratt's most famous for having at one point said, kill the Indian, save the man. This seems to have been his basic philosophy, that in order to Americanize or civilize an individual Indian child, all traces of traditional culture had to be driven out of that child, and they needed to be replaced with American cultural elements. So you come in with long hair, you lose it. We're going to give you a short haircut because that's more American and less tribal. You come in with a tribal name, well, we'll give you a new name, a new English name. You come in speaking a tribal language, well, that's not allowed here. You've got to speak English. You're not allowed to engage in traditional religious activities. We're going to put you in dormitories, segregate you by sex. We're going to dress you properly. And there are lots of images that were used for fundraising at the time of kids when they arrived with long hair and traditional dress, and then after they'd been there for a while with short hair and wearing these little uniforms that they were assigned at the Carlisle Military School. That was meant to make people feel that this was succeeding, this effort was succeeding in the process of civilization. Even within the same generation, we're taking a kid in a matter of months and converting him from a traditional tribal member to an American citizen. The instructional program is, the heart of it is given away in the name of the school. It's an industrial school. So they're not studying the great works of English literature. They're studying manual skills. The boys are learning carpentry, other sort of industrial skills. The girls are learning sewing and housekeeping and cooking and, again, other what we're seeing as gender-appropriate industrial skills. And the idea was then that these kids, most of them, would go home and teach their parents or their siblings or the next generation, and encourage them to come east to Carlisle or to another one of these boarding schools in order to be culturally assimilated, in order to be economically assimilated, mined into sort of a middle or lower class role, but that was perceived to be the best target area by the Friends of the Indian for this first generation of tribal members brought into the boarding school experience. They were assimilated linguistically, these kids, and they could encourage their family members and friends back home to engage in that as well. Now, there are a lot of people who went through the Carlisle program. Some of them became famous writers and sort of cultural intermediaries. Jim Thorpe, probably the most famous alumnus of the Carlisle program, who became, of course, an internationally recognized athlete and then went home. But there's a fairly heavy literature outlining the problem side of the Carlisle and boarding school experience, much larger literature than that, illustrating or arguing for the other side, certainly in modern literature. And what we recognize now is that there's a whole lot of trauma resulting to individuals, and it's multi-generational trauma. Because these individuals who were sort of dislocated, separated from their families, then returned, not sure who they were, what world they belonged in, and then that legacy gets passed down. Sociologists tell us from one generation to the next, and so this is an issue that's still present in a lot of families, this legacy of this boarding school experience. It's an experience that persisted, although into the 20th century, although never with the enthusiasm brought to it by these reform organizations and the government in the 1880s and 1890s. Now, the major piece of legislation that came during this period of reform of the 1880s, after the peace policy essentially finishes up, is the Dawes General Allotment Act. And this is the last thing we're going to talk about in this lecture. And it's a statute that we're going to return to in future lectures because, as I mentioned in the first lecture for the course, the Dawes Act is still with us today. And the legacy of the Dawes Act, the land tenure legacy of the Dawes Act, still affects the way that jurisdictional calculations are made when we're assessing self-governance powers of tribes and powers of states and powers of the federal government. Henry Dawes was the chairman of the Senate Indian Affairs Committee in 1887 when the Dawes Act was passed, and that's why it bears his name. The General Allotment Act was passed. And the goal of the act was to essentially effectuate the policy advocated by the Friends of the Indian, which at that time had become dramatic intervention in Indian country, a destruction of the communal land base, a forced distribution of individual parcels of land to individual tribal members, a cession of all the land left over, and as a result, a fairly rapid conversion of tribal communities into agricultural communities comprised of individual yeoman farmers, I suppose one can say, if one's feeling Jeffersonian. Individual participants in the market economy owing no allegiance to tribal governments, which at the end of the allotment period it was intended would disappear. This is aggressive assimilation. And it's what the Dawes General Allotment Act set out to do. And in a lot of ways, it succeeded. It certainly succeeded in its attempts to devastate the tribal land base. Those are statistics I want to give you in a minute, but let's understand first how it worked. And the mechanics changed somewhat over time, although it was basically like this. The executive was tasked to go reservation by reservation, one tribe's Indian country to another tribe's Indian country, and conduct a census in which all of the tribal members who were going to participate in the allotment exercise would come down to a central location and identify themselves. They would then become eligible for allotment and on a first-come, first-served basis would be instructed to select their allotment on a map that had the reservation divided up into squares that were eventually fixed at 80 acres of farmland or 160 acres of grazing land per capita, per person. So you'd come in with your family, you'd be on the allotment roll, or make sure you were on the allotment roll, and you'd say, well, I'd like that square for me, and that square for my wife, and that square for my oldest son, and that square for my younger daughter. And so every individual was entitled to a fixed amount of land. Once that was done, once everybody who had signed up had selected their land, the map would be taken down and everything that was unclaimed would be declared surplus land and either purchased by the government, with the purchase money going into a federal account in Washington to be managed for the benefit of the tribe, or sold by the government, acting as real estate agent. And in those instances, a lot of the lands that were never sold, continued to be collectively owned tribal lands. But the lands that were sold then were usually sold to non-Indians, and so non-Indians moved into what had formerly been the tribes, and may still be the tribes' Indian country. That's a legal question we're not going to talk about, but had formerly been completely communally owned by the tribe. Citizenship for allottees was a part of the plan. The lands would be held in trust, which is to say the United States would continue to own the title to the land, the old Johnson versus McIntosh discovery doctrine rule. The individual allottee would own an occupancy right to that land for a period of 25 years, after which the land would become vested in fee, the title to the land would become the property of the individual allottee, and the land could be sold, that restriction on alienation would disappear, or taxed, or borrowed against. It was essentially up to the individual at that point what to do with it. Now that 25-year period got extended by amendments to the statute, and it's indefinite. It can be terminated by application. But in many instances, the lands of allottees are still what we call trust lands. They're still owned, the title owned by the United States, with the occupancy right owned by the individual tribal member. The goal was to create a class of farmers, but in 1891 and 1894, Congress amended the General Allotment Act to allow for fairly widespread leasing of allotted lands. And a lot of tribal members said, oh, well, I'll just do that. I'll lease this land, and so my income won't come from my getting up every morning and farming. It'll come from my accepting rent from people. And that turned out to be a major problem with the accomplishment of the goal of conversion to agriculture. Another problem came because a lot of the people who took allotments were minors, and this invited non-Indian lawyers, for the most part, to step in and say, well, that person can't manage their allotment. Why don't you, the court, appoint me their guardian, and I'll manage it for them? This was widespread in Oklahoma. This is something that Angie DeBow talks about in her work. It was common in other places as well. Lawyers would collect long lists of hundreds of minor Indian kids for whom they acted as guardian. And in Oklahoma, for instance, it was these lawyers who were negotiating with the petroleum companies that were starting to come in at this time for revenues from oil and gas and that sort of thing. And the guardians were making most of the money, while the individual allottees in Indian country may have been making some money, but weren't making as much because the guardian's taking a lot out in brokerage fees and guardianship fees as well. That hadn't been provided for in the General Allotment Act and turned out to be a major problem. The 5 tribes of eastern Oklahoma were not included within the General Allotment Act, partly because they owned their lands in fee already, so they had to have a different process. That was part of the removal treaty deal. And when those lands are allotted, it's actually the tribal government that's signing the deed over, as opposed to the United States when the trust period ends. The Osage were also exempted. There was a separate allotment act for the Osage, and the Osage negotiated a different deal. They eventually agreed to, at least on a formal basis, the allotment of their surface lands, but they reserved collective ownership of their subsurface rights. And as we'll see when we look at the Shoshone case in a future lecture from the 1930s, the courts recognized that as a part of the tribal occupancy right, the tribes owned their subsurface natural resources rights. Well, the Osage reserved those, and so they actually, to this day, have what we call an underground reservation. The Osage tribe owns all the minerals, natural resources underlying Osage County, even though the surface of the land has been allotted, and that's a unique situation. The Miamis, the Peorias, the Saxon Foxes in the then Indian Territory, also exempted from allotment, had special allotment statutes passed separately. The Senecas in New York were not covered, and nor finally were the what were then called the Sioux lands in Nebraska. Now, the impact, and this is the point at which I'll close this lecture, was devastating. John Collier, Commissioner of Indian Affairs, we're going to meet in a future lecture in 1934, at a time when Congress was deciding it was time to stop allotting, to bury the process of allotment, testified that of 138 million acres in tribal control in 1887, By 1934, only 48 million acres remained. That's 90 million acres had been lost to tribes and individual Indians between 1887 and 1934. That's almost 2/3 of all Indian country. And that understates the problem, he said, because of what remained, the 48 million acres that remained, nearly half of it was desert land. It was the best land that got allotted, and much of it eventually sold out of Indian hands. Collier estimated that tribes had lost, and Indians had lost, more than 80% of the value of the lands that they held in North America in 1887 as a direct consequence of the General Allotment Act and the subsequent individual allotment acts that were passed by Congress. And on that sad and dire note, we'll finish and we'll resume the story looking at the Supreme Court's role in all of this in our next lecture.